Hello there, great people, and welcome yet again to another episode of Know Your Laws, where we talk on matters to do with law and legal affairs, always to educate you, help you learn new laws that govern you. On our previous episode where we talked on matters to do with divorce, of course, we elaborated the process in which a divorce case is taken here in Kenya, and we highlighted everything that you need to know. You can be sure you can catch that interview on our social media pages, Facebook at KirkTv Kenya and YouTube at KirkTv Kenya. And that is what brings us to our topic of discussion today, because when there is a divorce, the center of all is the property that was gathered in that particular marriage. And today we are going to discuss the distribution, or rather sharing, of the matrimonial property with my guest who is here in the studio. Welcome to the studio.
Thank you so much.
My guest is Kevin Doe. He's an advocate of the High Court of Kenya, who will help us talk about that discussion in matters to do with the distribution and sharing of matrimonial property. And just to begin our conversation in this particular topic, which is so much contentious, what is matrimonial property? For someone who would be asking, what really is that?
Matrimonial property is defined under the Marriage Act as the property that is acquired during marriage. So when you get married, both of you have property just before marriage that you acquired before marriage. But matrimonial property are those properties now that you continue to acquire when you are married. It can comprise of lands, it can comprise of shares, it can comprise of houses and various assets such as cars and debentures or other forms of property. But from the beginning, when you have the day you celebrate your marriage, from that point, if you acquire anything, it becomes part of the matrimonial property.
Of course, matrimonial property is, you've said, is a property acquired once people have gotten married.
Yes.
In terms of everything surrounding. Now, yes, as we get now into the discussion deeper, acquiring of matrimonial property. These are two people who are married,
yes,
and they have acquired property.
Yeah.
If that property is listed in the name of one of the partners, yes, while the other partner hasn't been listed in the property, yes, does that now amount to matrimonial property as a couple, or when the conflict arises, that separation now means the property remains to the one listed on the name listed on the property?
Okay, matrimonial property is defined as that property which is acquired during marriage. Now, for the division of matrimonial property, there are certain principles of law that will inform the court that on how to go about the division of our property. And the major principle that is adhered to is contribution. So previously, we used to have an English form of division of matrimonial property, where the old principle is that there are no moieties in marriage. That is a French word called moi, or mine. There is nothing like mine in marriage. That was the old principle of English law, borrowed from French law. So the courts never came and asked if there was a piece of bread or a loaf of bread, who bought the loaf of bread and where did you eat the loaf of bread? No, no, no. Once you get into that marriage, everything becomes belongs to everybody. The cars, the clothes, the lands, the assets. So the principle there was, at dissolution is 50-50. That was to be how they looked at it. So there was no this is you point to this aspect and say this is mine. You point to this aspect that say this is mine. Now, as the law developed in Kenya and under the various acts that have now come into force, is that now you have to prove contribution. So if the land was registered in somebody's name, what did you contribute to that acquisition? How did you contribute to that acquisition so that you can claim a part of that land that is not registered in your name? Famously, there's a decision that has been issued at the Supreme Court that says you cannot just be in a relationship and all you do is hover around the remote, and then when things go wrong and you are splitting the property, you claim half. No, you have to prove your contribution. Now, there are various methods of proving this contribution. It can be monetary, where you might have contributed money towards the acquisition of that property. Or it can be something that might be equated to money. For example, what did you do during the marriage? Did you give birth? Did you take care of the children? Did you take care of the husband when he was going to work? Who was ironing the clothes? Various other forms of contribution are allowed. And also the qualifications, the foregone opportunities. For example, maybe you are a doctor and you married a man who's also a doctor. Then you said, there is no reason why we should both work. We have enough money. I'll stay home with the kids. You go to work. So the qualifications and the foregone, the foregone income that would have been making had you not been married will also be considered. Recently, also, they said giving birth is something that is part of the contribution to the marriage. So there are various schools of thought, obviously, on that. And once you have a contribution, now you're able to claim or clear basis for a claim to the property. Sometimes it is not a court case. Sometimes it goes into mediation, and parties just discuss. This is what I brought into the marriage. This is how we can agree. And you come up with a mediation agreement, and it's acceptable to the court that you people have agreed, and then you split the property according to how you have agreed.
Yes. The distribution, or rather the division of matrimonial property, in some occasion is characterized by greed, malice, and maybe self-interest. And now, when let's say a matter has risen and gone to court, in sharing of matrimonial property, is a property that involves two people who we presume were together, or rather were married. Yes. What does the court look now to substantiate whatever claims are being put by both parties, in each party claiming the share of that particular matrimonial property?
Yes. What I'd say is that marriages, when they are breaking up, are usually very emotional situations during the lifetime of an individual or an adult. So you might find the blame game still going on. What happens first is that there must first be a divorce. A divorce proceeding must first commence and conclude. Then once the divorce proceeding concludes, then there is an application for division of matrimonial property, just between the time when you get the decree nisi and the decree final, because the divorce process starts and concludes at the first instance with a decree nisi. Then you wait 6 months, then you get the final decree that declares you guys divorced. In between, that is usually the period when there is an application made for the division of that property. So the court will obviously require you to file an application with a supporting affidavit, where you substantiate all your claims under oath. And if you have documents to prove that you indeed have contributed, you'll produce them in the affidavit. You can put in a birth certificate of the children. You can put in receipts showing what you have done in acquisition of the properties. You can put in photos of moments that you discussed, or you were doing something in contribution to that marriage. Maybe you are maintaining the house or things like that. So the court will look at that type of evidence. And then when it is during the type of hearing, you give your side of the story under oath. Then you are cross-examined, and that now you're tested on your inconsistencies or your consistencies in your evidence before the court. And that's now when you will be asked very hard questions to bring out the truth. Then the judge will be able to judge on credibility of your evidence, will be able to judge on the form of your contribution, and then weigh on how much you have contributed in somehow monetary terms. Obviously, the other side will come up with their own documents, will say this property anyway, the title deed is registered in one person's name. The agreement for sale was between one party of the marriage and some third party, and the payments towards acquisition of that land, that car, that those shares were wholly made by one party. That the basic there is the children born in the marriage, if it gets to that type of down and dirty, that the children of the marriage are actually not children of the marriage, and may produce DNA evidence to say these children were never mine. They actually, one of the reasons we got divorced is because of the adultery, and this was the fruits of that adultery. Then you're able to have both sides heard. When you come to court, you'll be examined, you'll give your evidence on oath, then you'll be cross-examined, maybe it's your wife cross-examining you or his lawyer or her lawyer, and you'll be asked tough questions, and then the judge will be able to judge on the man's credibility, on his evidence, and on the weight to be attached to his evidence. Then the court will now be able to make a sober judicial determination on how that property will be divided.
You mentioned about claims such as adultery and others arising when there is a difference in a division of matrimonial property. Are those circumstances, or rather, is that something like adultery? Is that a circumstance or rather a situation that can make the court deny or rule against one of the partners while determining division of the matrimonial property?
What happens is with adultery is that it negates that aspect of contribution to the marriage in the sense of giving birth to children or issues of the marriage. What ends up happening is that you have come to court saying one of the ways you have contributed to the marriage was the birth of those children. If there is now a question as to the paternity of those children, then that aspect of you arguing that you contributed children to the marriage now becomes something that is up for determination. So it becomes an issue for determination. And if they were not part of the paternal issue, then obviously that is not a contribution. Then it will be discounted that you did not make any contribution to the marriage. However, the issues that arise during divorce sometimes get they sometimes affect credibility during the determination of that question. So in as far as your credibility is being questioned, issues to do with adultery, non-consummation, denial of conjugal rights will also come into play during the determination of this latter part of matrimonial proceedings where you're dividing the property.
What I'm getting from the entire discussion is that the division of matrimonial property basically bases its determination on the contributions of both parties towards what they are terming as matrimonial property. Yes. In other scenarios where a partner contributes into the matrimonial property on the basis of we are together for something like, let's say love, you contribute towards that marriage, not necessarily because you want to get involved in that in the matrimonial property. Let's say for a wife contributes towards the family property, but under the basis of the love that is in the marriage, but not later on to claim my matrimonial property. In a scenario like that one, can the wife now reverse to be able and say, I contributed this because of the love for my marriage, but now I want to term it as part of my contribution to the matrimonial property?
For in law, there's nothing like love. There's only property, rights, and responsibilities. During marriage, basically, in society there is love and affection. But at law, it is property and rights and liabilities. So, for example, the wife was providing all the food in the house. The man was just paying the rent and the school fees. So later on, her evidence will be in chief that she contributed the upkeep, the entertainment, the food, the clothing for the children and for the husband and things like that. During that subsistence, she bought or she gave a loan to the husband. Maybe in the morning he didn't have fare, gives him a bit of money to get things moving. Then so the husband's side of the story will be, he took her out on dates. We used to have family outings. So you take them out on vacation in Dubai, things like that. So both, it is the story of a lifetime. Now this story of a lifetime only the only aspect the law is concerned is monetary. Is contribution that is equivalent to monetary. The provision of services, for example, the cleaning, the giving of bath, the various ways that marriage was made a marriage by those activities. So when you put a value to that is now when you can now be able to look at this property and say, maybe this 100 acres here, maybe the wife should take maybe 20 acres.
Okay.
Or the husband should take 10 acres. And that is it. We don't really want to get into the intentions of why you are doing it. We just want to understand how were you living your lives as a married couple, and was there actual contribution into the various ways that the law recognizes as being relevant to the determination of that question. How do I determine or divide this property?
Just to be precise, in a setup that is not a legally accepted marriage by the Kenyan law, where people maybe have been cohabiting for, say, more than even 20 years.
Yes.
In that scenario, is there claim of matrimonial property? Understanding that in division of matrimonial property, the law looks at things like the legality of the marriage.
What happens with situations like that is that the division of matrimonial property can only commence when there is a divorce.
Okay.
So if there is no divorce, there is no matrimonial causes. So when you look at it, if there was no marriage, then there cannot be any divorce. If there is no divorce, there cannot be any division of matrimonial property. For such persons, the best advice that can be given is to sue as if they were not married. Maybe under the law of contract, under the law of trusts, under the law of property, but not under the Matrimonial Causes Act. So you might have yourself having no rights under the Marriage Act. Your recourse will be in another area of law.
Does the presumption of marriage apply in that case?
No. What happens with presumption of marriage is where there has been a death. And that is now another side of the law. That is the law of succession. Okay. The law of succession is basically related or emanates from the law of death. So by the time the person was dying, had they been living together for a long time in a notorious way such that everyone treated them as husband and wife, and will it be justified for such a spouse who has been left behind to inherit the property of the deceased spouse? Now the spouse here is spouse in quotes. It's just the court will just have mercy and say, here there was a marriage. I believe this person there was a presumption of marriage, and this person should be able to inherit. However, the controversy also emanates because various judges have found that the law on presumption will not apply in certain circumstances. The most important being where somebody comes to court and says, no, we were married under customary law, we went to Azez and we exchanged the cows or the bride price, and basically I should be presumed a wife even if I don't have a certificate. What the courts have said is that for customary marriage you cannot claim them through affidavit evidence. You have to come up with a certificate from the Attorney General's office. So you cannot presume customary marriage. You have to prove customary marriage, and the only way you can prove customary marriage to this day is by an affidavit, not by a certificate. However, if you just come to court and you say, we were living together for this long, and we were husband and wife even for a long time, everybody was treating us as husband and wife, you are actually asking to be considered a common law wife, a common law wife or a common law husband, in the sense that the courts will not say this type of marriage has not been outlawed. It is outside the statutes. So it is not we don't want to be You don't want your marriage to be presumed a customary marriage. You don't want it to be presumed a Christian marriage. You don't want it to be presumed a marriage under the Marriage Act. You just want it to be presumed as a common law marriage. Pure and simple, then that will go through. However, for aspects of division of matrimonial property, you will not have a chance. But for division of deceased person's property, you might have a chance.
I was going through an article that was talking about it was the rulings of the division of matrimonial property, and the court had ruled against the children of that, or actually children had taken their father to court, saying that the father sold matrimonial property without consulting them. But the court at the end ruled against the children, saying that the parents do not have to consult the children when it comes to the ownership of matrimonial property. And that begs me to ask the question, do children have any role in the matrimonial property, or rather in the division of matrimonial property?
No, they do not. Matrimonial property, divorce, matrimonial causes are only between husband and wife.
Okay.
The children have no part to play. The only time children will come as a part to play is that one party will be adducing evidence that they contributed children into that marriage. That is only as far as where the children are concerned. A party might come and say, I contributed to the marriage by paying school fees for the children. The children don't have anything to say when the parents are fighting or divorcing or dividing property. So I believe that decision by the court was on all fours.
Okay.
During the lifetime of a father and a mother, those things can be argued. But where one party dies, then you'll have issues. Now you'll go into another type of law. That is a law of succession. But if you have adult children, they are considered dependents. So you cannot, for example, a father dies, then the mother wants to take all the property of the husband and to exclude all the children.
Okay.
The children will now have a problem with that. They can now go to court and say, we want to get direct inheritance from the death of our father. Obviously, if there are certain cultural prohibitions, then those will work against the children, because most cultures don't have that type of inheritance where the wife and the children get everything together. So you might find the Judicature Act applying African law to such a situation.
Okay.
However, if it was a polygamous situation, then you'll have the children inheriting as a unit and the wives inheriting as a unit, and everybody is getting a unit. That's it.
Okay.
Unfortunately, in such circumstances, you might find you're not dealing with the law of divorce and matrimonial property. You're dealing with the law of the estate of a deceased person, which is a separate side. Yeah.
And just as we conclude, I just want your comment on just in this context where I just came across a ruling where they said that in the case of this X and X, will avoid quote mentioning the names. The court held out that when property is purchased jointly by both spouses and registered in the name of the husband with the wife's approval, a resulting trust can be in our favor. On the contrary, again, the court in the case of B and C denied its power to pass title from one spouse to another. That is a context of division of matrimonial property. Just as we conclude, because my director says time has far much gone, we would, how is your take on that particular context where one, the court rules in this favor, then another court rules against?
What happens under the law of matrimonial property is that you have to prove contribution. So if you prove that you contributed half the money that was used to acquire the property, then you're entitled to half that property. If, on the other hand, you contributed in other ways and forms, you have to prove that other ways and forms, and you'll be given your share. In the sense of a resulting trust, that type of trust is another area of law altogether. It's not an area of law within division of matrimonial property. The law of division of matrimonial property has been somehow clarified with the Marriage Act, in the sense that it has provided ways of proving contribution.
Okay.
Now, when you look at resulting trusts, that's a law of trust where you basically are looking at what did you do to deserve that property, whether you are husband and wife or whether you're strangers. So the court will look at, if this property was to be acquired in this way and it was registered only in one person's name, the resulting trust will result. Then we'll be able now to have you get the property.
All right.
Yeah.
Thank you so much for making time to be able to elaborate on the matrimonial property. I know it's a very wide and lengthy topic, which is a very contentious one as well.
Yes.
We also did with you the law on divorce, which you can catch that interview on our social media platforms. We talked about the law on marriage and also the law on divorce, all procedures laid out in our previous interviews, which you can catch them on our social media handles, Facebook KirkTv Kenya and YouTube at KirkTv Kenya. And that is where we wind up our discussion matters to do with the division of matrimonial property. Always hoping that you have been able to pick one or two things. And my name is Chris Sambo and my guest has been Kevin Doe. See you in the next episode. Goodbye.